In the shadow of castles and cathedrals, far from royal courts and noble judges, peasants gathered in barns, woods, and village squares to hold secret trials. No kings, no written laws, only whispered oaths, shared grief, and raw justice. These weren't myths or tales, they were real systems born from desperation, survival, and quiet rebellion. And for centuries, the elite had no idea. How did these hidden courts function? Who did they punish? And who did they protect? In medieval Europe, justice wore many faces, some cloaked in velvet and gold, others cloaked in dirt and wool. The royal courts of kings and lords operated with scrolls, seals, and scribes, dispensing rulings based on charters, writs, and codes of law that only the educated could interpret. But beneath this high legal canopy, a separate system existed. It wasn't written, it wasn't sanctioned, yet it governed millions. For peasants who made up over 90% of the population, the king's justice was distant in every sense. Royal courts were often days away, both in geography and in access. They spoke Latin or Norman French, not the dialects of the fields and farms. Proceedings favored landowners and the church. Legal fees, travel costs, and the time lost from work made formal justice not only impractical, but impossible for many. And so, a different kind of justice evolved. This alternative was built on custom, not codified laws, but inherited memory. A system based on oral tradition, where precedent was not written but remembered, where fairness wasn't dictated from above, but interpreted through the shared values of a local community in Anglo-Saxon England. Long before Norman bureaucracy took hold, village moots served as early examples of this grassroots approach. Free men would gather under a tree or near a well any public space would do. Disputes were aired aloud. Elders weighed in. The decisions they reached weren't backed by written law, but by communal consensus. And long after the Norman conquest reshaped England's legal structure, these customs didn't vanish. They adapted, operating quietly alongside the king's growing court system. Similar traditions existed across medieval Europe. In the Holy Roman Empire, Weisdemer oral declarations of customary law were recited by memory during local assemblies. In parts of rural France, peasant communities used prud'hommes, trusted local figures who resolved disputes based on local understanding, not royal codes. Scandinavian things, Iberian consejos, Slavic vechish, represented community approaches to order and fairness. These weren't chaotic or lawless affairs. They had their own structure, rhythm, and legitimacy. But their power came from tradition, not decree. These systems thrived because they were tailored to the people they served. Local justice understood context, who had been wronged, what had been promised, what the land had yielded that season. They judged not just the letter, but the spirit of conduct to the nobility and church. These peasant-led systems were unofficial at best, heretical at worst. Yet in practice, they maintained order where royal law could not reach. They kept peace in the hamlets and valleys the king's men rarely visited. They offered resolution to those too poor to pay for parchment and process. This justice wasn't glamorous. It left no marble statues, no law books bound in leather. But for generations of peasants, it was real and it worked. It was how trust was rebuilt after betrayal, how disputes were settled without swords, and how a silent, unwritten legal memory endured, carried not in books, but in the minds of those who had no other choice. In medieval Europe, the courtrooms of kings and lords were never built for peasants. Justice, in theory, applied to all. In practice, it was a weapon of the elite. Royal and manorial courts were distant, sometimes dozens of miles away from rural villages. A trip to court meant days of walking, leaving behind fields that demanded attention and families that depended on every hour of labor. Even reaching the court was only the first barrier. Legal proceedings were conducted in Latin or Norman French, far removed from the vernacular tongues of common folk. Most peasants were illiterate. They could not read charters, understand writs, or argue points of law. Formal legal documents might as well have been written in code. Representation by legal advocates was rare, and where it existed, it came with a price tag well beyond the means of a subsistence farmer. Cost was a constant obstacle. Fees were charged for everything from filing a case to having a judgment enforced. Even local manorial courts, which operated under the authority of a lord rather than the crown, levied fines that could bankrupt a family. A peasant disputing the theft of a cow might win the case, only to pay more in court costs than the animal was worth. But worse than the cost was the bias. These courts were not neutral. Lords held legal authority over their tenants and often acted as judge and beneficiary. A dispute involving land, taxes, or obligations was nearly always skewed in favor of the landowner. A reeve, bailiff, or steward might oversee proceedings, but they answered to the manor, not the people. Justice served feudal power structures. Peasants were expected to comply, not to contest. Corruption was common. Inquests could be manipulated. Fines could be invented. Testimonies could be ignored if they came from the wrong mouth. The church offered ecclesiastical courts for matters involving clergy or spiritual offenses. But here too, the system protected its own. Tithes were extracted. Penances were public. Confession could be used against the poor, while immunity was quietly granted to the influential. Faced with this reality, peasants turned to what they trusted, their community. They created systems based not on parchment, but on shared memory and oral custom. Disputes were handled within the village, where everyone knew who had wronged whom and why. Justice became a matter of collective memory and mutual survival. Punishments were decided not by abstract law, but by practical need. Restitution mattered more than precedent. Harmony mattered more than hierarchy. In parts of 13th century Germany, entire villages ignored distant courts and organized local assemblies to judge theft, adultery, or even murder. In rural France, elders known as prud'hommes settled disputes without the interference of nobility. In England, the traditions of the tithing and frank pledge systems persisted, binding groups of households together to enforce communal responsibility. This wasn't rebellion. It was survival. When formal law became a tool of oppression, peasants responded with a law of necessity. They built justice from Bellinot out of defiance. But because there was no one else to turn to, justice for peasants often began in the shadows, not behind courtroom doors, but in places hidden from the eyes of authority where risk met necessity. Across medieval Europe, underground trials were held in spaces that offered both cover and familiarity. Barns at the edge of villages, abandoned mills, open fields shielded by tree lines. In regions like Flanders and the Rhineland, forest clearings became makeshift courts. In southern France, dry riverbeds or ruined chapels were used when discretion was vital. These weren't casual choices, they were calculated. Visibility meant danger. A wandering bailiff or local priest could report the gathering as sedition. Secrecy was more than a precaution. It was the only way these courts could function. Royal law did not recognize unofficial assemblies, and lords viewed them as a threat to their jurisdiction. Discovery could lead to arrests, public punishments, or fines that crippled entire households. In some cases, the entire village might be held accountable for illegal gatherings. That fear, however, didn't stop them. It only shaped how they met. Timing mattered. Most of these courts met under the cover of night. Moonlight often served as the only source of illumination. Quiet footsteps, hushed voices. In some areas, trials were scheduled during feast days, harvest festivals, or funerals, moments when people gathered anyway, allowing secret meetings to hide within public events. A wedding might bring together families from several hamlets. A wake could serve as cover for dispute resolution that had been building for months. Witness accounts from 14th century Alsace describe villagers gathering on All Saints' Day in remote barns, not just to pray, but to settle land feuds and moral violations. In parts of Wales and Brittany, these gatherings often took place near ancient standing stones or wells believed to carry spiritual authority, symbols that added weight to community judgments. Despite the risk, these places carried legitimacy in the eyes of those who used them. The barn wasn't just a barn, it was a courtroom. The elders' bench became a judge's seat. The soil beneath their feet became legal ground. This wasn't law imposed from a castle. It was law rooted in survival and trust. The secrecy, though forced, shaped something deeper: solidarity. Everyone present had to believe in the process, or it didn't work. And in that quiet, hidden space, peasants forged something powerful: justice, not granted by rulers, but created by the ruled. The courts of kings dealt in treason, land rights, and taxation. But for peasants, the crimes that mattered most were personal, rooted in survival, trust, and daily labor. These were not always offenses written into royal law, yet in the eyes of a village, they were no less serious. Stolen grain was among the most common and consequential cases. A missing sack of barley in a manor might go unnoticed. In a peasant household, it could mean starvation. In 14th Yorkshire, oral records from local manorial inquiries mention grain theft as a recurring accusation, often handled before it reached any official court. Suspects were usually known neighbors, distant kin, or seasonal workers. But bringing a charge in front of the manor's steward risked reprisal, so villagers handled it internally. Testimonies were collected, storage pits were inspected. If guilt was confirmed, the punishment might include forced repayment, public shame, or exclusion from the next communal harvest. Land disputes were another frequent cause of conflict. Boundaries were often based on memory, not maps. If a fence moved a few feet, or a plough crossed into a neighbor's strip, arguments followed. In the Basque valleys of the 13th century, some villages maintained oral boundary rocks or ancient footpaths to avoid noble intervention. When disputes arose, respected elders or local assemblies resolved them quietly, reinforcing the terms through witnesses and communal consent. But the most delicate cases weren't always about property, they were about behavior. Betrayals of trust, failure to contribute to collective work, or breaking social norms often led to judgment. In Central Europe, particularly in Swabia and Bavaria, Nachbarschaft and local neighborhood courts addressed these breaches. A villager who refused to join a communal fence repair or skipped out on their share of field maintenance could be summoned before the community. The sentence might involve extra labor, restitution, or ritual apology. Adultery was one of the most sensitive offenses, though technically under the jurisdiction of ecclesiastical courts. Many rural communities handled such matters internally. In parts of medieval Italy and rural France, witnesses would be questioned informally, and if the claims held weight, the social penalties were severe public disgrace, loss of standing, or even symbolic acts of humiliation. These trials didn't seek to moralize. They aimed to maintain the fragile fabric of trust. Physical violence was also addressed, especially when it disrupted village harmony. A fight between laborers, an assault during a feast, or threats made during a harvest could trigger a local inquiry. If the victim was seriously injured, a lord's attention might be unavoidable, but for most cases, resolution was local. Apologies were demanded. Compensation was arranged. In some Scandinavian communities, this mirrored ancient Wergild practices, value to injury and resolving the matter through agreed payment. What united all these offenses was their communal impact. They weren't crimes against the state, they were offenses against relationships. In these hidden trials, justice wasn't about law and punishment. It was about restoring balance where trust had been broken. And in the absence of written codes, the people judged by what they remembered, what they saw, and what they were willing to live with. In the medieval countryside, prisons were a luxury few villages could afford. Most didn't have jailhouses, guards, or the means to detain anyone for long. But that didn't mean justice went unenforced. Peasant communities developed their own forms of punishment, rooted in shame, labor, and exclusion. Justice was public, visible, and personal. It had to be. There were no cells to hide behind. Reputation in the village was everything. Honor determined access to land, labor, even marriage. So when someone was found guilty by a local court, the punishment often attacked that standing directly. One of the most common forms was chivalry and noisy, mocking procession meant to humiliate. It was used across Europe, especially in France and England, often targeting adulterers or men who failed in their roles as husbands or workers. The condemned might be paraded on a cart, faces covered in soot, surrounded by clanging pots and shouting neighbors. It was loud, it was humiliating, and it stayed in memory far longer than a fine. Exclusion was another tool. A person who refused to repay a debt, skipped communal labor, or disrupted a harvest might be banned from future participation. In parts of the Holy Roman Empire, this meant denial of access to shared resources, like the village oven, the well, or the grazing fields. In agricultural societies, that kind of punishment was devastating. Without access to water or tools, a peasant couldn't feed a family or maintain a livelihood. In more severe cases, exile was imposed. The offender would be ordered to leave the village, often within a set number of days. This wasn't just physical displacement, it was social death. Outside the village walls, there was no safety net, no community, no shared protection. For many, it was a harsher sentence than confinement. Sometimes, punishment came in the form of enforced labor. A thief might be ordered to work the victim's fields during planting season. A man who damaged property might be forced to repair it under public supervision. This form of justice was transactional and restorative. It focused less on retribution and more on rebalancing the scales. These methods weren't perfect. They could be influenced by local politics, personal feuds, or community bias. But they were designed to work in societies where cooperation was survival. The worst punishment wasn't physical pain. It was being cut off from the group that your life depended on. In villages where the king's laws were distant and written justice felt irrelevant, peasants created systems that protected their way of life. Punishment wasn't about deterrence. It was about memory, visibility, and the quiet power of being seen and judged by your own dot. In the formal courts of medieval Europe, women were seldom seen and rarely heard. Legal authority belonged to men clergy, lords, scribes, and officials. Women, even in matters that directly affected them, were often treated as legal minors, requiring male representation. But in the shadow courts of the countryside, the unwritten systems of peasant justice offered a different reality. Within these informal assemblies, women took on roles that would have been unimaginable inside royal or manorial chambers. In many rural communities, especially across parts of Central Europe and the British Isles, elder women served as advisors and even their authority came not from title or document, but from knowledge of custom, kinship ties, and the social memory of the village. They were particularly influential in cases involving domestic disputes, adultery, moral conduct, and childbirth accusations, matters largely invisible to male-dominated institutions. In 13th century Swabia, accounts from village councils show older women being consulted in cases of suspected infidelity and social misconduct. Their judgments weren't just moral, they were grounded in an understanding of consequence. A household disrupted by betrayal could threaten a family's survival. These women weren't delivering abstract rulings, they were helping stabilize the village. In Scandinavian communities, especially in Iceland and Norway, sagas and local annals include references to women participating in wing assembly discussions, particularly when they involved lineage, inheritance, or female honor. Though often sidelined in written law, oral traditions kept the memory of their influence alive, and in some Slavic regions, women elders were known as babkas, consulted in community disputes and decisions that required social mediation. Testimony was another domain where women's voices mattered. In informal courts, rigid hierarchies broke down. A woman who had witnessed theft or violence could speak directly without needing a male intermediary. Her word could sway decisions, especially when supported by others in the community. This was not equality in a modern sense, but it was a form of recognition absent in official proceedings. The role of women in these systems wasn't accidental, it was the result of necessity. In peasant life, women managed households, tended livestock, oversaw harvests, and nursed the sick. They understood how decisions would ripple through the fabric of daily life. Their judgments weren't ideological, they were practical. Where official justice silenced them, hidden justice made space. In the fields, barns, and kitchens of medieval Europe, women didn't just obey custom. In many cases, they were the ones who remembered it and enforced it. Hidden courts worked because they stayed hidden. But when they surfaced, whether through rumor, denunciation, or accident, the response from the ruling powers was rarely tolerant. To the nobility, these gatherings were a challenge to feudal control. To the church, they bordered on heresy. In the mid-13th century, a series of inquisitorial reports from the Rhineland region detailed what ecclesiastical authorities called unlawful assemblies. These weren't gatherings for worship or feast. They were trials, conducted without priest or lord, in barns and groves. Witnesses described villages gathering to judge disputes, assign punishments, and even impose public penance. The Church labeled these trials as signs of spiritual disorder. Some were investigated under the same protocols used for rooting out heretical sects. In southern France, following the Albigensian Crusade, the Inquisition expanded its focus beyond religious dissent to include unauthorized forms of justice. In 1319, a local prior in the Diocese of Toulouse filed a report accusing a group of peasants of hosting what he called tribunalia, clandestine tribunals. The accused were fined, and 2 were excommunicated. No formal charges of heresy were pursued. But the implication was clear. Spiritual authority could not coexist with lay judgment, especially when it took place in secret. Nobles saw these assemblies as threats to their jurisdiction. In England, during the reign of Edward I, royal justices received complaints from landowners in Norfolk and Kent about villagers refusing to bring their grievances to manorial courts. Instead, they were convening unlawfully, resolving thefts and land disputes outside the manor's control. In one case from 1288, a reeve was removed from office after it was discovered he had helped organize such a gathering. The crown called it a breach of feudal order, but while the authorities viewed these trials as rebellious, the reality was often the opposite. These informal systems weren't attempting to replace royal law. They filled in where it failed. In many regions, justice from above was inconsistent, expensive, or entirely absent. Local courts preserved order, resolved feuds, and protected community cohesion. That role was poorly understood by outsiders. Lords assumed any challenge to their monopoly on justice was subversion. Bishops saw moral judgment outside church control as blasphemous. But most hidden courts didn't exist to append power. They existed because power rarely bothered to show up. Still, the consequences for discovery could be severe. In parts of Bohemia, communities caught holding unauthorized trials were fined collectively. In the Burgundian Netherlands, Duke Philip the Good issued an ordinance in 1455 explicitly banning judgments rendered outside official authority. Violators faced public flogging or, in repeat cases, exile from the province. These crackdowns drove the practice deeper underground. Villagers became more careful. Gatherings were tied to legitimate events: feast day, a harvest celebration, a funeral. Justice continued, just more quietly. For centuries, rural communities operated in this legal twilight, caught between survival and suppression. To the authorities, these trials were disorder. But to the people who held them, they were the last defense against chaos. Not revolution, but preservation. Not defiance, but necessity. The village courts of medieval Europe may have faded, but their legacy hasn't vanished. The instinct that drove peasants to resolve disputes through shared customs, memory, and consensus still exists, in places far from medieval barns, and in systems far removed from parchment and seals. Across South Asia, panchayats, traditional village councils, continue to mediate land disputes, family conflicts, and social violations. Though officially informal and often outside state jurisdiction, they command authority grounded in history and community respect. In rural India and Pakistan, these councils operate much like their medieval counterparts. Elders convene, testimony is oral, and judgment aims at social repair rather than legal precedent. In many parts of sub-Saharan Africa, customary courts function alongside or beneath the formal legal system. The Akali Ruit Query in Uganda or the Gakaka courts in post-genocide Rwanda were not invented anew. They were rooted in long-standing community-based practices of truth-telling, accountability, and reconciliation. The Rwandan Gakaka system, for instance, heard over 1 million cases between 2005 and 2012, far more than the country's formal judiciary could have managed. Unlike the peasant courts of the past, they emphasized restoration over incarceration. Even in developed nations, echoes of hidden justice persist. In some rural parts of Eastern Europe, informal dispute resolution is still used to settle feuds that would otherwise linger in state backlogs. In immigrant and diasporic communities across Europe and North America, cultural councils and elders quietly resolve issues without drawing attention to legal authorities. These bodies handle disputes not because laws are absent, but because formal systems are viewed as slow, expensive, or incapable of understanding local context. Community mediation programs, now formally sanctioned in places like the United States, the UK, and Australia, mirror many of the principles that guided medieval village justice. Neutral facilitators, mutual agreement, voluntary participation, and an emphasis on repairing harm rather than assigning blame. These systems are often deployed in neighborhood disputes, schools, and small civil matters, offering an alternative to adversarial courtrooms. The impulse to create justice close to home by people who understand the situation, the culture, and the consequences, as old as organized society itself. When states become overburdened, when courts seem distant, or when communities lose trust in legal institutions, these older methods resurface, not as relics, but as practical responses. The hidden courts of medieval peasants weren't anomalies. They were expressions of a human need for fairness, accountability, and peace carried out in the only way available. That same need still shapes justice today, in ways formal history rarely records. For medieval peasants, law wasn't just something imposed from above. It was something carried from one generation to the next, not in books, but in memory. In the absence of written codes or official courts, justice survived through storytelling, witness, and repetition. The hidden trials they held weren't acts of defiance. They were acts of preservation. Every village had its unwritten history. Who had broken trust? Who had mended it? Which boundaries had been disputed? What promises had been made and forgotten? These things weren't filed, they were remembered. And when justice was needed, that memory was summoned, not as hearsay, but as evidence. In these trials, the oldest voices often held the most weight. They weren't more educated. They simply remembered what others had forgotten. This wasn't nostalgia, it was infrastructure. In societies where literacy was rare and documents could be forged or misunderstood, memory became the foundation of truth. The community itself was the archive. Everyone knew who had borrowed a tool and failed to return it, who had helped during a bad harvest, who had lied one sand, never again. Guilt and redemption weren't abstract ideas. They were lived realities, tracked by people who saw each other every day. And so, the purpose of these trials wasn't simply to punish, it was to restore. Reconciliation mattered more than verdicts. Harmony mattered more than legalism. The village didn't seek to destroy its members, it sought to survive with them. But survival required trust, and trust required accountability. In this way, judgment served as a form of healing, not vengeance. This collective memory gave small communities something larger courts often could not: context. A royal judge might rule on a theft based on statute. A village court might consider the harvest that failed, the child who fell sick, the neighbor who offered help. The decision wasn't softer, was more complete. Even when official authorities tried to erase these systems, they couldn't erase the memory behind them. Stories of how wrongs were righted without violence, how communities stayed intact without outside enforcement, continued to circulate. And long after these trials ended, the habits they taught, witnessing, remembering, and restoring, remained embedded in the culture. These secret courts weren't just informal mechanisms of justice. They were rituals of remembrance, acts of mutual recognition in a world that often refused to recognize them. When the powerful looked away, the people looked to each other, and in doing so, they preserved not only peace but identity,